Hi, good afternoon, everyone. I'm Charlie Wang, Associate Professor and a member of UNSW Law's Herbert Smith Freehills SIBO Center, and I'm delighted to welcome you to the first session of the 2021 SIBO webinar series. The topic of this webinar is the RCEP and its implications, opportunities, and challenges. I would like to begin by acknowledging the Bedigo people who are the traditional custodians of the land where UNSW law stands. I would also like to pay my respect to the elders, both past, present, and emerging, and extend that respect to other Aboriginal and Torres Strait Islanders who are present here today. As you know, we are facing the most significant public health challenge after World War II. Distrust, geopolitics, and populism are chipping away the achievements of globalization in the past decades. We are facing not only the challenges of the pandemic, but also a more fragmented world. Luckily, there's a piece of good news for globalization at the end of 2020. Regional Comprehensive Economic Partnership, short for RCEP, has been formed. It covers 15 countries in the Asian Pacific region and has almost 1/3 of the world's GDP. People now have a high expectation of the partnership, counting on the new partnership could lead the world out of the potential economy swamp left by the impact of the pandemic. More importantly, both Australia and China are in the partnership. Today, I'm glad to announce that we have 3 great international scholars on the panel. Each of them is bringing a fantastic talk for us on RCEP. The first speaker is Dr. Lu Wang. Lu joined UNSW Law and Justice as a lecturer in August 2018 after completing her PhDs at the University of Liverpool in the UK and Xi'an Jiaotong University in China. The primary area of Lu's research is on international and comparative economic law, with a particular focus on international investment law, international arbitration, state-owned enterprises, and China's regulations of foreign trade and investment. The topic of her talk is investment rules in RCEP, a China perspective. The second speaker is Associate Professor Kun Fan. Associate Professor Kun Fan is a award-winning scholar with a research focus on alternative dispute resolution, ADR, online dispute resolution, comparative legal studies, law and society. She is an academic council member of the Institute of Transnational Arbitration and executive committee member of the International Task Force on Mixed Mode Dispute Resolution. Prior to UNSW, she held academic positions at Faculty of Law, McGill University, and Chinese University of Hong Kong. She was also a visiting scholar of Harvard Yenching Institute. She has named Norton Rose Fulbright Scholar in Arbitration and Commercial Center in 2017 and received numerous awards to recognize her academic achievements. Professor Fan also has extensive experience in ADR practice. The title of her presentation is RCEP's Implications on International Dispute Settlement. Then the third speaker, and also is our last speaker of today, is Associate Professor Wei Huan Zhou. Dr. Zhou is the Director of Research at the Faculty of Law and Justice, UNSW Sydney. He published in the fields of international economic law, particularly in the nexus between international trade and China. His work has appeared in all top journals in the field and in some of the best journals in the broader field of international law. Currently, he is a co-secretary of the Society of International Economic Law. Prior to UNSW Law, he was a trade and commercial lawyer and a legal consultant at the WTO. His talk is RCEP leaves SOEs and international subsidies unregulated. So let's welcome our first speaker, Lu. Her topic is investment rules in RCEP, a Chinese perspective. Lu, please.
Thank you very much, Charlie, for your very kind introduction. Hello, everyone. Great to see you online. I'm very privileged to be the first speaker in the first SIBO launch webinar in this year. and join with my colleagues to discuss about some topical issues under the world's largest trade and investment agreement to date. So my presentation will focus on investment rules under the RCEP agreement and its implications for investment governance, and I will address these issues from a Chinese perspective. So to set the discussion in context, the RCEP agreement covers a wide range of matters and contains a chapter on investment, which is expected to consolidate and modernize the investment liberalization, promotion, facilitation, and protection regimes applicable to the RCEP parties. The investment chapter under the RCEP reflects a trend of international investment treaty making that investment provisions have been frequently negotiated in the context of free trade agreements and macro-regional free trade agreements. Commentators label the RCEP agreement as China-led trade agreement, but it's actually an ASEAN-centered trade pact which aims to create a more comprehensive and beneficial economic partnership among the ASEAN member states and its regional partners. Nonetheless, no one would overlook the role of China, especially considering that China is the largest Asian economy and the largest trading partner of the countries in Asia. On the other hand, China appears to play a more proactive role in investment rulemakings in recent years due to the need to protect its outward investment and enhance foreign investors' confidence in inward investment. At the same time, the international investment law regime has evolved dramatically in that it responds to challenges arising from the changing landscape of cross-border investment. For example, new investors like state-owned enterprises, impacts of COVID-19 on global production network, and also the increasing complexities in states' investment policies, such as the need to balance competing interests between protection and regulation, as well as the tension between openness and control, etc. So many scholars, teachers, and other stakeholders have been discussing the reform and the future of international investment law. Against this background, I believe that it's timely and useful to assess the investment rules under the RCEP agreement from a Chinese perspective and to reflect on its implications for China and beyond. The RCEP investment chapter contains provisions covering the 4 pillars of the investment, including investment protection, investment liberalization, investment promotion, investment efficient. So I will address each pillar through the lens of Chinese investment treaty practice. In terms of investment protection, I acknowledge that as a whole, the RCEP investment chapter does not appear to offer significant refinements or innovations or breakthroughs over the standards contained in international investment treaties of some member states. But at least from the perspective of China's approach to investment treaties, the RCEP investment chapter has reflected China's recent treaty practice on substantive standards of international protection, including rules requiring payment of compensation for expropriation with further clarification in the annex, fair and equitable treatment in customary and international law minimum standard of treatment to alien, and also the compensations for losses due to conflict and civil strikes and the free transfer of investment-related capital, etc. Notably, China under the RCEP investment chapter does not only commit to afford post-establishment non-discriminatory treatment, including national treatment and MFN treatment, but also extends the obligations to the pre-establishment phase. At the same time, the investment rules under the RCEP incorporate further explanations and also exceptions to clarify the scope and application of the investment protections to address the state's concerns over the expensive jurisdiction and unexpected interpretations of investment tribunals. For example, the definition of investor includes natural person and legal person that seek to make investments, and in terms of seek to make, it refers to has taken concrete action or actions to make an investment, and where the notification or approval is required, it as to an investor that has initiated such notifications or approval process. And the juridical persons include both private and governmental entities. And there's also examples that can be found in the provisions such as definition of investment and the deny of benefit clauses. And it also contains provisions to preserve the state's right to regulate. For example, the provisions on reservations and non-conforming matters, and also a separate security exceptions to investment chapter, in addition to the general and security exceptions in the exception chapter, which will apply to the whole agreement. In terms of investment liberalization, a remarkable development is that China, for the first time, commits to afford pre-establishment of active list. Well, this is not very surprising, as China has adopted the same approach in its investment, new investment agreements with the European Union. It's the first time that China has agreed so in its free trade agreement. In addition, the investment chapter under RCEP also contains detailed rules with respect to prohibition of performance requirements, which go beyond the multilateral obligations under the TRIPS agreement, and also the provisions on the senior management and board of directors. Although the liberalization rules are subject to schedules of specific commitments and schedules of reservations and non-conforming matters, which could be extensive, they have significant and far-reaching implications for China's investment government. First, the commitment to investment liberalization under investment treaties has locking effect to market access commits under domestic instruments and may trigger further reforms in the future. The RCEP reflects China's latest developments on market access and amendments to inactive list. And the inactive list approach will largely enhance the transparency of the state investment policies to foreign investors. More importantly, China has committed not to set new restrictions to market access, and in the foreseeable future, China will need to review and revise its domestic regulations on foreign investment in accordance with its and obligations under the international agreements with respect to investment liberalization. And also investment liberalization key priority chapters of agreements. As China experiences in investment services, the quality of Chinese free trade agreements investment provisions have also improved incrementally. In particular, the RCEP extends liberalization in trade in goods and services to investment. And since the reserved sectors listed in RCEP are for both trading services and investment, the RCEP agreement likely will encourage investment liberalization in member states, including China, by relying on existing momentum for trade liberalization to create new opportunities for investment liberalization. As some commentators said, this reflects the economic realities of international production networks in which trading services often support cross-border investments. Beyond that, the COVID-19 has accelerated the transformation of the global production network and has intensified the existing tension between openness and control in national investment policy making. So in this context, the progress of investment liberalization relatively modest compared with other free trade agreements will be helpful to create opportunities in the region and remove barriers and to trade and investment. In fact, the RCEP strives to boost the competition in a way that drives productivities, and this is of significant in the post-pandemic. Another feature of the RCEP investment chapter from the perspective of China is to incorporate separate provisions on investment promotion and investment facilitation in the investment chapter. In particular, negotiations for multilateral agreements on investment facilitation is still underway among WTO members. In this sense, the agreements on investment facilitation in a macro-regional free trade agreement can be considered as a big achievement. In the context of investment facilitation attempts to create the necessary environment for all forms of investment in simplified procedures for investment application and approvals, and promote the dissemination of investment information to provide assistance and advisory services to investors. In addition, the investment facilitation provisions include to assist protected investors and cover the investment to amicably resolve complaints with the government bodies and to establish mechanisms to make recommendations to relevant government bodies addressing issues affecting foreign investors. However, the provisions use the term of shall endeavor to, or to the extent possible, and also exclude the investment facilitation from any dispute resolution proceedings under the RCEP agreement, leaving doubt on implementation of such rules in practice. I think the main reason why RCEP investment chapters appear disappointing to commentators is because it fails to address the several issues that call for institutional reforms at both national and international levels. For example, the RCEP investment chapter does not contain an investor-state dispute settlement. Instead, it provides a work program on ISDS provisions. I'm not going to discuss this in detail as my colleague Quinn will speak on that, but I would like to say that at least the RCEP investment chapter does not close the door to the potential, to the possibility for establishing ISDS. And another issue is the state-owned enterprises, and my colleague Wei Huan will address this issue. To some extent, it's not surprising that RCEP does not regulate the SOEs due to the level of development in Asian countries and the reliance on SOE investment, especially considering that the RCEP is an Asian-driven trade pact. The SOE disciplines at international level request better and deeper domestic reforms. But it's also notable that China opens the idea of joining the CPTPP, which contains robust rules on SOE disciplines. And China is taking efforts to finalize the RCEP and speed up negotiations with Japan, Korea, consult the economic and integration and also agree to discipline SOEs in the investment agreement with the European Union in its new investment treaty. In addition, the RCEP investment chapter does not contain provisions on sustainable development, and the recent investment treaty including Chinese social clauses safeguarding the environment and co-labor standards, but the RCEP investment chapter does not contain, and the reason is very similar to the lack of provisions on state-owned enterprises. So to conclude, if there's a conclusion, the RCEP is tasked for moving barriers to trade and investment and boosting the economies in the Asian Pacific regions through regional economic integration rather than for a deeper institutional reform in the parties and the region. For China, the RCEP investment charter strives to maintain core investment protection standards and preserve states' right to regulate for public policies, and it reflects China's recent practice on investment protection with clarifications and refinements to key terms, and also reflects China's incrementally heading to investment liberalization. And more importantly, I think the RCEP will have far-reaching implications for investment governance as a significant step for China towards investment liberalization and deeper regional cooperation, especially consider that Asia has taken the EU as China's largest trading partner. The conclusion of RCEP agreements is a positive step forward for free trade and multilateralism, and the achievements in RCEP to benefit from opportunities to speed up its negotiations on with other states joining in the future. All right, I think I shall stop here. Thank you very much, and I look forward to the discussions later. Back to you, Charlie.
Thank you. Thank you very much. Thanks, Lu. I know it's breakfast time in your place. I'm sorry for the connectivity issue. It seems for the globalization, which you have a very long way to go. Thank you very much. Then the second topic. The second topic is brought by us from Professor Kun Fan. Her topic is RCEP's implication on international dispute settlement. Kun, please.
Thank you. Good morning, good afternoon, or good evening, ladies and gentlemen. It's a great pleasure for me to participate in our first CBEL lunch seminar. So my talk will focus on the RCEP's implication on international dispute resolution. As Lu already mentioned, one of the key features of the RCEP is perhaps the so can you hear me clearly? Okay, yeah, I will try to speak slowly. I hope that you will be able to hear me well. So one of the key features of RCEP is, in fact, the absence of the investor-state dispute settlement mechanism, despite the great effort spent on the investment team trying to negotiate really a very comprehensive ISDS mechanism, but eventually no consensus were reached. Some states like New Zealand, India, Malaysia, Indonesia, for instance, were expressly against the inclusion of ISDS. So RCEP was eventually concluded without an ISDS regime for now. And Article 10.18, if we turn to the next slide, please, states that the parties shall enter into discussion within 2 years of entry into force and conclude the discussion within 3 years. So that gives us at least 5 to 6 years of gap before we see any ISDS provision in the RCEP. And I think this might be a pragmatic way to resolve the current issue of investor protection during a backlash against ISDS and leave this controversial issue for future negotiations. And also it's important to note that MFN clause expressly carves out the application of the clause of international dispute settlement procedure or mechanisms. So what then is left for the investors if a state party to the RCEP commits any breach of obligations under the RCEP's investment chapter? So if we turn to the next, are some options for the investors. So one option under Article 20, it states that each party affirms existing rights and obligations under the existing investment agreements. So, and in fact, many of the 15 RCEP states already have international investment agreement among themselves, which contain ISDS provisions. So practically, this would mean that the investor from RCEP party can still rely on those existing treaties with ISDS mechanism to bring an investor-state arbitration. So this is the first option, which already existed before RCEP and will be remaining in place. The second option is Chapter 19 that's imbued under the RCEP. That's a state-to-state dispute settlement mechanism. So that would mean that if a party to RCEP commits any breach of its obligation under the investment chapter, the investor could then request their home state to espouse the claim and file a claim against the hosting state through a state-to-state dispute resolution mechanism under the RCEP Chapter 19 itself. And this, although this comes with an important carve-out. So Article 1711 carves out the pre-establishment rights. So which means that Chapter 19 is not applicable to disputes relating to admission or approval of foreign investment during the screening process applied by the parties. And finally, Article 19 also said the state parties, upon espousing the claim, can still choose a forum from their existing investment agreement. So that's the third option. Let me give you a more concrete example of what it means. So if we turn to the next slide, let's assume that you have an investment dispute between the Chinese investor or the Australian government, or vice versa. Right? So what's the investor? So in case of any breach of the RCEP state, against any obligation within the investment chapter, the investor could then seek to rely on any existing investment treaties. In this case, there are coexisting two treaties, the Australian-China BAT that were signed in 1988. So that was the earlier generation BAT that China entered into, and which coexist with the more recently entered into Australian-China FTA, which contained an investment chapter. So they could rely on those existing treaties. And the option provided, for instance, under the Australian-China BAT includes consultation, negotiation, proceeding before competent judicial and administrative bodies. Or given it's an earlier generation BAT, it has a more restricted scope of jurisdiction. It provides dispute relating to the amount of compensation payable under expropriation, then it can be resorted by arbitration. It also envisaged exit arbitration. Bearing in mind at the time, 1988, neither China or Australia has become a member to exit yet, but it later became, so exit would also be an option. But given that this is an earlier generation BAT, the investor may be more likely rely on the FTA, which also has an investment chapter, and it provides also the option for investor of unrestricted scope of jurisdiction under the exit arbitration, and also possibility of arbitration under ancestral rules or any other arbitration institution or under any other arbitration rules that the party have agreed. So the investor does have a number of options under the existing treaty. Or alternatively, they could also rely on the state-to-state dispute resolution mechanism under Chapter 19 if they ask their home state to espouse the claim and file a claim against a hosting state. Or they could also ask the home state to bring a claim under existing dispute settlement mechanism within existing treaties, such as the Australian-China BAT. So I think this concrete example just illustrates the complexity of this treaty web, right? You see a web of coexisting international investment treaties, which is a common phenomenon in international investment agreements. But the RCEP just brings in another layer of complexity to the picture. But for now, what we have under RCEP is a state-to-state dispute settlement mechanism, which is greatly inspired by the WTO dispute settlement mechanism. So now I will focus on highlighting a few features of the RCEP's inbuilt dispute settlement mechanism. So the next slide gives you a flow chart of the RCEP. And you will see the general process is quite similar to that of the WTO, right? So the consultation procedure, panel procedure, and enforcement procedure. Article 19.7 also said the parties to the dispute may at any time agree to voluntarily undertake an alternative method of dispute resolution, including good office, conciliation, or mediation. So there are some similarities with the WTO mechanism, but in light of the criticisms against the WTO dispute settlement system, such as the lack of efficiency, the long procedure, lack of transparency, the RCEP also attempted to make some modifications. The next slide just give you an overview of some of the major differences. So if we turn to the next page, so the Article 19.2 set up the objective of the chapter is to provide effective, efficient, and transparent rules and procedures. So again, the spirit is quite consistent with the WTO, but there are some specific modifications. One major difference is the lack of appeal mechanism under the RCEP. As we know, the WTO have an appellate review process with a standing appellate body to review the issues of law covered in the panel report and legal interpretations developed by the panel. But notably, there's no such appeal mechanism under the RCEP. Article 1915 provides the finding and determination of the panel shall be final and binding. There is a compliance review procedure, so where the parties to the dispute, if they disagree on the existence or consistency with this agreement of any measures taken to implement the final report, then the dispute shall be settled through a recourse through the compliance review panel, but that is still quite different from the appellate review mechanism. And if we look at the timeline overall, since there's no appeal procedure and also there's no need to wait for 60 days for the adoption of the panel report by the members as in the WTO system, overall there's an attempt to improve the efficiency of this procedure. But how it plays out in practice remains to be tested. Now, more specifically, on the next slide, as to the establishment of the panel, there's no list of the panelists for the parties to choose from, but there are some specific requirements as to the qualification of the panel, which is quite common in international arbitration rules, such as expertise or experience in law, trade or other matters covered by the agreement, requirement of independence and impartiality. There's also additional qualification requirements for the appointment made by the appointing authority. And in the case of chair, where possible, the chair should have served on the WTO panel or appellate body and have expertise or experience relevant to the subject matter of the dispute. There is also a nationality restriction, again, very similar to the WTO or many arbitration institutional rules. But under the WTO, nationality restriction applies to all panels, not just the chair. The RCEP only restricts the chair not to have the same nationality with any party or third party. And to compensate that, it added also the chair can also not be a resident of any of the parties to the dispute to enhance the perceived impartiality of the panel. And the next slide, about the panel procedure that were set out in Article 1913. More detailed rules of a procedure will be adopted by the RCEP Joint Committee. It has not yet been publicly made available. The Joint Committee is due to have its first meeting within 1 year after entry into force. So the detailed rule of procedure might be produced at that time. And finally, the next slide, in terms of remedy. So what you get under the state-to-state dispute settlement mechanism is a final and binding panel report where a losing state party is then ordered either to bring its measures into conformity with RCEP or carry out its obligations under the RCEP. And as mentioned earlier, there is also a compliance review procedure. So the form of remedy is either the compensation or retaliation. But to note that the compensation here is made by the hosting state to the home state. There is no direct compensation made to the investors. And so that's one limitation of this mechanism. Or disputing parties, then the home state may suspend the concession given to the host state under the RCEP. It's also interesting to note that under Article 1918, there is a special and differential treatment involving the least developed country parties. So what's the prospect? Currently, if we turn to the last slide, there are certain limitations under the RCEP dispute settlement mechanism for the investors. First of all, there's a big hurdle for the investor. They have to persuade their home state to espouse their claim, which is not always easy or possible, especially if the claim at stake is relatively small. And also, there is no direct compensation made to the investors. So at least for now, I think RCEP may not be frequently used by the investors to resolve their investment dispute. And instead, investors might prefer to rely on their existing investment agreement, which contains ISDS. But what about the future? As per Article 10.18, member states are expected to resume negotiation within 2 years after entering into force. So it will be interesting to see whether and how member states might incorporate ISDS into the RCEP. So, and there are two particular trends that's worth to be observed. One aspect is in light of the discussions surrounding ISDS reform, right, whether an appeal mechanism initiated by the EU might be incorporated into the RCEP. There's already an increasing incorporation of the appellate mechanism in the region. So, for instance, the Singapore-USA FTA, the China-Australian FTA, the India's new model BAT already contemplated creation of an appellate mechanism. And EU-Singapore Investment Protection Agreement and EU-Vietnam FTA provides already a permanent investment tribunal as well as a permanent appellate tribunal. So whether we might see the same trend occurring in the renegotiation of the ISDS in RCEP is something interesting to be observed. Another interesting trend is inclusion of mediation in a growing number of bilateral and multilateral investment treaties. And so in light of the strong mediation culture in Asian states, and the entry into force of the Singapore Convention, so whether we might see more specific provisions related particularly to investor-state mediation is another interesting trend to observe. We also see the trend that's already occurring. Again, similarly, as I mentioned, the EU-Singapore Investment Protection Agreement, EU-Vietnam Trade Investment Agreement already incorporated a code of conduct for mediator and a very comprehensive rule for investor-state mediation. And some treaties like Indonesian, Australian CEPA, and the Hong Kong UAE BAT even included a mandatory conciliation procedure as a precondition to arbitration. So whether we might see that trend occurring under RCEP is again something to be observed for future. Now to conclude, RCEP is not perfect. There are still some matters to be improved, but I think the signing of the RCEP, especially during the pandemic, signals a very positive sign towards multilateralism, and it also shows the importance of Asian Pacific region in the global economic order. So I think I'm going to stop here, and I welcome any questions and discussions at a later stage. Thank you very much.
Thanks, Kun. Thank you very much. So the third speaker is Wei Huan. His topic is RCEP leaves SOEs and individual subsidies unregulated. Please, Wei Huan.
Thanks, Charlie. And thank you for everyone who is participating and joining us today. Before I get to my topic, I think I need to kind of make an acknowledgement and disclaimer, if you like, on behalf of the team, that what we are presenting today are really very specific topics and areas under RCEP. We haven't actually talked about the very broad implications economically and politically in relation to RCEP, especially the questions and issues about tariffs reductions, trade liberalization, how RCEP dealt with non-tariff barriers and services. So those topics have been discussed widely since the RCEP was signed. And so that's why we're choosing to focus on certain topics that have been less discussed in the field. As Quinn said, we shouldn't be underestimating the implications and positive effects of RCEP, and especially when one takes into account how RCEP innovates, if you like, rules of a region, and in other areas as well. So my topic today will be really focusing on, again, a very specific area, which is state-owned enterprises and industry policies. I'll be talking about, firstly, why this is important, and secondly, what has RCEP has achieved in this area, and finally, comparing RCEP's developments in this area, if any, to the existing rules under the World Trade Organization and the major recent free trade agreements, if you like, particularly the CPTPP and the CAI, the comprehensive agreement between EU and China on investment. Again, my talk will be focusing on the issues relating to industry policies, industry subsidies, and state-owned enterprises. Next slide, please. So why this is important? If you look at the diagram, and it might be a little bit messy, but the diagram shows how significant trade distortive and restrictive measures have been on the rise in the past decades, and especially after COVID. And the fact that over 6,000 subsidies are being implemented in G20 countries shows how significantly the countries try to resort to different kinds of policy instruments, including subsidies, to deal with the pandemic and for other purposes. Now, back to subsidies. We need to accept that the subsidies are imposed for legitimate reasons in many cases, especially in dealing with the pandemic. But we shouldn't underestimate the impacts on trade of subsidies because that they have enduring impacts and will continue to impact on trade after the pandemic. Now, it depends on how countries deal with the subsidies, whether they will actually phase out subsidies that tends to be unnecessary after the pandemic. But again, given the past experience, it is difficult for governments to really negotiate an approach to further reduce industry subsidies, and this kind of negotiating momentum is growing at the moment after significant policy and academic debates that is ongoing. So I think this shows why the topic of industry subsidies are important. Now, how this are actually related to SOEs, state-owned enterprises. Next slide, please. So, firstly, I think we need to acknowledge that SOEs are widespread in many jurisdictions. It's not really just a question for China or other countries in the RCEP, but they're actually widespread in many other countries, including in the more advanced economies like the EU and the US. Now, I wouldn't actually go through everything I put on the slide, but just highlight how SOEs may actually be used or by itself to distort trade. Now, the first and one of the most significant points there is that SOEs normally receive benefits and preferential treatment from governments, and therefore, when they engage in commercial activities, they have a competitive advantage. Now, this relates to the competition policy as well, but in the trade law area, it's really about the different kinds of financial and non-financial support provided to SOEs that may distort trade and affect the competitive condition for other players. And secondly, it's about the governments use SOEs to provide preferences and other supports to other entities in the economy, and therefore provides competitive advantages for those entities as well. So there are major two ways that the SOEs may be used by the governments as a commercial actor, if you like, as opposed to as a public function in commercial activities that may affect the competitive advantage and also distort trade. Now, these kind of effects are not actually just localized. They can actually go overseas. Now, for example, if you have an SOE which establish a commercial presence in a foreign jurisdiction and then provide goods or services in that jurisdiction, while this SOE actually acquires different kinds of support domestically, then that could actually provide a competitive advantage for the SOE in a different jurisdiction. Next slide, please. So, given the facts and the discussions about why industry policy subsidies and SOEs are important, and it is a little bit disappointing to say that the RCEP does not really provide any additional disciplines based on the existing ones. Now, I know that Lu made a point about that many of the countries are actually at different stages of development, and therefore it is difficult to negotiate rules on SOEs. But bear in mind that 7 of the members in RCEP are also members of the CPTPP, which I will come back later, has very significant additional rules on SOEs and industry policies. So, I mean, I don't think this is not achievable. Why this has not actually been further developed under RCEP is subject to debate. But from my perspective, that the fact that the RCEP does not really have any additional rules on industry subsidies, has no additional rules on SOEs, is under development. And the only relevant provision under RCEP that might be related to SOEs is actually set out in the competition policy chapter, which says that when you apply competition laws and regulations and enforce them, you need to make sure you apply them across the board. And again, you will say that there is kind of a disclaimer or an exception there, qualifying that requirement basically says that you could actually deviate from that obligation if you're trying to achieve a public policy or public interest, which can only be broadly interpreted, if you like. And finally, even that, only relevant provision to SOEs and industry, to SOEs, not really to industry subsidies, is not subject to dispute settlement under RCEP. So how these RCEP rules on SOEs and industry policy subsidies compare to the existing rules? Next slide, please. So I was just going to go through very quickly about the relevant WTO rules. The WTO does have some rules on state capitalism and state trading enterprises, state-owned enterprises, and these rules are actually scattered into different provisions under the WTO, and the most relevant one is actually the Article 17 of the GATT, which really just say that state trading enterprises, you must not discriminate when you provide goods and you buy and sell goods. The WTO panel body has interpreted that provision as limited to non-discrimination. Now, we do have the language of commercial consideration. So state trading enterprises in your commercial activities in relation to purchase and sale of goods, you need to only consider, make decision based on commercial consideration. But the panel body has interpreted that as an element, under non-discrimination. So the only obligation under Article 17 is a non-discrimination. Now, you could, and we know that trade remedies, including anti-dumping and countervailing measures, which is anti-subsidy measures, are widely used by countries to counteract the effects of subsidies or dumping practice. Those could also be relevant to industry subsidies or the practice of SOEs in selling a product under the definition of dumping. Now, in addition to the general rules under the WTO, newly acceded members also agreed to additional rules. That includes China, Vietnam. They have additional rules under their own accession protocol and other accession instruments, particularly the report of the Working Party. And these rules, especially in the case of China, has extended significantly beyond the general WTO rules. Next slide, please. I'll just go through very quickly on these things. 2 points to make on this paragraph in China's Working Party report, in the accession to the WTO. It really it says that, state-owned enterprises, state-invested enterprises, you must make your purchase and sales solely on commercial considerations. Now, this looks very similar to Article 17 of the GATT, but this is actually may be interpreted as a separate obligation, in addition to non-discrimination. Right? Now, we need to acknowledge that this is not really set out in detail. So what is commercial consideration? But, this is at least provides the room for an interpretation in a way that could constrain the activities of SOEs. Next slide, please. Another even broader obligation under China's WTO accession instruments is this provision. Basically says that China is under obligation to allow prices to be determined by market forces in all sectors, goods and services. Right? Again, not detailed, not set out in very detail. So it may actually fall short of applicability in practice, but at least it provides room for the WTO tribunals to develop certain rules and evidence requirements under this broad obligation. Next slide, please. So when you come to CPTPP, which is the later and one of the most significant mega regionals, if you like, it provides more detailed rules on SOEs, and firstly, it provides the definition of SOEs. Now we need to note that the definition of SOEs is essentially based on ownership. And there is the argument that the definition has lost sight of the fact that the government may actually have influence or significant influence on a state-owned on a state enterprises, even if it does not have the majority interest in it. So, but in any event, the CPTPP has set out a number of additional obligations. And I think that takes into account the China's WTO obligation and develops further and detailed rules around these obligations. For example, it actually says purchase and sale of goods and services, right? So it's not only limited to goods but also services. It needs to be compliant with non-discrimination and the requirements of commercial consideration. And also dealt with industry subsidies in the CPTPP. It's called non-commercial assistance. It basically takes from the definition of subsidies under the WTO subsidy agreement, and it prevents the use of such assistance to SOEs or provided by SOEs to cause adverse effects on a foreign player. So this is the significant development in a sense that includes services, and it clarifies that it's both the assistance provided to SOEs and by SOEs, and it actually highlights the fact that this assistance may actually cause spillover effects across the board. Transparency is also very important. It requires the responding party to provide information requested on SOEs. So these are very important things that has been really criticized under the WTO. So I see these are very, very significant developments, despite the fact that the CPTPP provides significant exceptions as well, especially under the non-conforming measures. But that is really how countries actually can come to an agreement to these significant developments in the SOE chapter. And non-conforming measures, including, for example, across the board exemption from from the obligation, some of the obligations, the major obligations for subnational SOEs. So, for example, only central SOEs are regulated, and also country-specific exemptions, and some of them has one non-conforming measure, some of them have more than 10 non-conforming measures. Next slide, please. So finally, I just want to touch upon a bit on CAI. CAI is the most recent concluded agreement, and it focuses on investment, but some of the methods CAI takes can be compared to the CPTPP. And you can see that the developments in CAI, in terms of the covered entities, it takes a step further to recognize that ownership may not actually be the only criterion, and then to provide rules on if a government has influence on the entity would also be a covered entity under the agreement. And secondly, again, because the focus on investment, so the same non-discrimination and commercial consideration requirements are slightly different in terms of the subject matter they're dealing with, and in terms of who needs to be treated in a similar manner. And again, because of the focus on investment, the non-discrimination rules also applied to establishment and operation of a entity, a foreign entity. It takes a very similar approach, providing non-conforming measures. Now, the full text of the CAI has not been released yet, as I read it last time. So we don't yet know exactly what are the non-conforming measures, but we can wait and see. Now, final point on CAI is the significant development on the transparency rules on industry policies, especially in relation to services. So this is a very important development because under the WTO, the General Agreement on Trading Services does not provide any concrete discipline on subsidies. So in this respect, the requirements of transparency in terms of services subsidies in the listed service sectors could be a step forward and could provide a model for future negotiation under WTO. What is the takeaway from all of this? I think that first, RCEP is not really the agreement we're going to use if we are trying to deal with industry subsidies and SOEs. But despite the fact that we don't really have significant development or any development under RCEP in terms of the rules on industry subsidies and SOEs, we still have some rules to use. The starting point will be the WTO, and if the governments are also parties to the other plurilateral or bilateral agreements, they could also look up the relevant provisions or sections in these agreements and try to see what are actually regulated and to bring a case under these separate agreements. So I'll stop there and happy to discuss further.
Thank you very much, Wan. I think we are a little bit running out of time. If you have a question, just feel free to publish it in a Q&A session. I'm finding I will pick one question with the most like to ask it, the presenters today. I don't think we have time to ask all those 3 or 4 questions, maybe just one. If you see any questions that you like, you just feel free to put like on that question so that I can ask them. Okay. Now I see. Yes, now I see a question with 4 like. Okay, then that's it. So the question is I think it's for Kun, right? What role might China play when member states of the RCEP resume negotiation on interstate dispute settlement? Please, Kun.
Thank you. Thank you for the question. Well, I think China will probably play quite an active role in the if member states resume negotiation about ISDS. And in fact, China has been quite proactive in the discussion of ISDS reform recently. So for instance, in China's proposal to the Central Working Group 3 on the ISDS reform, China made quite a few detailed proposals, and the starting position is ISDS still plays a quite important role, right, in protecting the rise in investment. So it's a mechanism that in principle should be maintained. But of course, there are flaws in the system, which, a lot of criticism, including the lack of error correcting mechanism, lack of stability and predictability of the awards. So recognizing this, I think China seems to be supporting this idea of establishing an appellate mechanism proposed by the EU. As I mentioned in the presentation, China-Australian FTA already contemplated that they should start negotiation with a view to establish an appellate mechanism, although it hasn't resulted in a substantive outcome. So I think that's probably one aspect that China might play an active role. Another aspect is, again, promotion of mediation. So I think it's interesting to know that there was the recent organization, International Commercial Dispute Prevention and Settlement Organization, that were actually led by China and particularly emphasized mediation and dispute prevention. And that's also accept investor-state dispute. So I think China might also play an active role in terms of promoting investor-state mediation.
Thank you, Kun. I saw quite a lot of questions over here. I think maybe in the future we can let the presenters have individual, like a lunch webinar separately. I think that could be a good idea. Thank you guys very much. Time flies. I don't think I need to recap what the presenters just presented. They're very good. All three topics being discussed are vital for us to understand the implication of our RCEP. They also will evoke more echoes in academia, I think. I believe RCEP, although it is developing, will bring the world more prosper rather than conflicts. Last but not the least, I need to thank SIBO for the excellent chance for us to discuss RCEP over here. Also, I on all speakers, a big thanks for the great presentations. Without excellent SIBO staff, Fion, Jen, Henry, and Sophia, this webinar wouldn't be organized successfully. I'm sincerely appreciative to what they have done for the webinar. More importantly, thank you all for participating in today's session. Have a great day, and a goodbye for now.